Number 19, People v. Stephen Sidbury.
Good afternoon, Your Honor. Stephen Strother from the Office of the Appellate Defender on behalf of Stephen Sidbury. I'm going to begin by addressing our sufficiency claim. Your Honors, this case is about whether a metal box attached to a door outside of which a fire could not spread is a building, as that term is defined in the penal law. It's not. We are asking this court to construe the term building such that items attached to a building are considered a part of the building only when setting fire to them would pose a risk to the larger structure or the people inside. We believe that lines up with the text and purpose of the statute far better than respondents.
So in this prison, the box was permanently attached to the cell door?
I don't actually think it was necessarily permanently attached. It certainly can be detached from the door. So
are you suggesting it was meant to be taken on and off on a regular basis? It wasn't fixed or screwed or
Oh, it's screwed into the door, yes. I'm just saying that it is detachable. It can be removed.
There are things in your home, they can be. You have mirrors that are affixed to a wall. They could be taken down, but they're meant, in a bathroom, for instance, they're usually meant to be there for a period of time. Are you saying in this instance, because it can't catch fire, because of the metal nature, is that what makes it not?
That's a major part of it. So we're arguing that, so the purpose of the arson statute is to protect buildings and people inside of them from dangerous fires. This if you look at the testimony on appendix pages 608 and 609, the officer makes clear that a fire set within one of these ports can't spread outside
So
of
it could be a part of the building, but it just can't catch fire, arguably.
So I would argue that if something cannot spread, it's an object attached to the door. Objects in buildings are not necessarily a part of the building under New York law, because New York only goes by the ordinary definition, which is a structure with roof and wall. So there's always an open question about whether objects in a building are a part of a building. This is an object, a piece of jail property. It has been attached to the door, but a fire within it can't spread to the door, the cell walls, the floor.
It's more than attached to the door. It becomes part of the door, at least from the pictures that I've seen.
So I think that's a semantic distinction, Your Honor.
Well, if you remove it, then the door has a hole in it.
If you remove it, of course, that's true.
Well,
but
the purpose of installing it is to put a hole in the door, isn't
What's
it? The purpose of installing it is to put a hole in the door. It's so that you could pass things through the port, right?
That's correct, yes. You put it there so you can pass things through. I do want to make clear that in this case, there's no testimony that it's ever removed from the door. Actually, the testimony is that the fire happened around 5 o'clock in the afternoon. Mr. Sidbury's taken out briefly and brought right back to the same cell later that day. So all of the concerns that are raised in respondent's brief that, oh no, there's a hole in the door, it's no longer usable as a door, doesn't really seem to be.
Counsel, before you leave your first point about what's the building and what's not the building, I know where you stand on the cuffing port. You said that that's not part of the building. Where do you stand on the door that the cuffing port is used on?
So defense counsel at trial conceded that the door was a part of the building, and we are bound by that concession. I'm not saying we would agree with that if we were arguing it afresh, but.
So if the defendant here had set the door on fire, so I don't know, poured an accelerant on the door and set the door on fire, and the same concessions had been made, this would be a very different case.
It would be a different case for a very specific reason, though, and that's because if you pour accelerant on a door and set it on fire, the fire spreads throughout the building. The people inside of it are now at risk of death.
Well, this is magic accelerant. It stays on the door. The thing this fire might spread, but the thing that lights on fire immediately is just the door. Is that the same case as this one or a different one?
I believe that because we are bound by trial counsel's concession, yes, that would be the building, the door there, in that circumstance. But we want to make clear that we believe that the hypothetical can't be limited to magical accelerant. The entire purpose of the statute is that it's protecting the people inside the building.
So you agree that a bathtub inside a home is part of the building?
No, I don't.
You don't, okay.
No, I actually think you would need to prove that. I think that under our rule, yes, it would be. I actually take that back, yes.
Thank you. Okay, so then someone starts a fire in the bathtub. No curtains around it, nothing around it. That would not fall under the arson statute? Because it won't spread beyond the The bathtub?
No, because a bathtub is not the building. This is similar to like other cases. We've had cases in this state where someone sets a PlayStation on fire in a living room. It doesn't spread past the PlayStation. That's arson in the 5th degree. It's fire to property. Just because it's inside of a building doesn't mean that it counts as the building, because the state defines that as its ordinary meaning.
But you told me you agreed that the bathtub is part of the building.
Only if it spreads to the rest of the building, actually. The bathtub, if it gets put out while
I
it's in the
see.
bathtub, that's just the burning of an object in a building.
Okay, but we've held that charring is sufficient. We don't say it has to spread for damage. Charring, right?
Well, sure, charring of the building itself would be sufficient to be arson in the 2nd degree.
So in this case, in Judge Rivera's example, charring of the bathtub, you'd say not part of the building?
Not a part of the building. No, it's an object inside the building. You can't say that a fire to every single object within a building is the building. Our request here.
What things then in that bathroom are not part of the building? Are you saying nothing? Fixtures, nothing is the
No, no, no.
building? It's only the structure itself, nothing that's attached to it?
We would say the structure itself, and then anything that's attached to the structure.
Okay.
That if you set that on fire, it could spread to the rest of the building and harm people in it. That would also
So
count
a
as the
tub
building.
that is attached to the walls of that bathroom, you
If
still
the
say...
bathtub is attached to the walls, then you
Yes.
set the bathtub on fire,
Not
then
standing on the
yes.
4 legs, that's pretty, but that's not what I'm talking about.
If you're talking about a bathtub attached to the walls,
Yes.
then yes, I agree with you that that would be a part of the building.
Okay, so if it was charred,
If the bathtub was charred?
yes, I'm now following Judge Singas's hypothetical, just to kind of get it all the way through.
Sure, I think that that would count. I think our rule accounts for that. We're asking for a rather narrow rule. We're asking for
So if the cuffing port or the door was charred in this case,
only if the door was charred, just the cuffing port. And the door here wasn't charred, and indeed no court below ever found that it
we
was.
disagree with you that the cuffing port is integral to the door and is thus part of the door is not functional, given that it's a prison without that cuffing port, and it is charred, do you lose?
I don't think so, and here's why. I think that the prosecution makes a lot out of the concept of integrality or critical to the structure. The problem there is that they can't actually define what that means, and they know that, which is why they go to the real property concept of fixtures as the way they're going to define what counts as integral or critical to the structure. This court cannot go down that road because it creates major problems. The purpose of the real property concept of fixtures is to determine the value, money value, of real estate for the
Well,
purposes
you
of sale.
agree that a door is part of the building?
Yes, a
yes?
door is part of the building.
Okay, so is a doorknob part of the building?
Oh, wait, I'm sorry. I thought you said you didn't agree that a door was part of the building, but you were constrained into this case because it was admitted below.
Yes, so I'm saying that I think I'm forced to agree that a door is a part of a building, yes.
Okay, all right.
Or this door?
Yeah,
I think that's
yes,
the
I'm
Chief
forced to
Judge's
agree that this door
clarification.
is.
This door, but if I'm saying generically a door, you would say no, and you would say the doorknob is also not, correct?
I would say that a door, it is detachable, it is movable. I do think that a door, just like the bathtub example, it's something that's attached to the larger structure, and if you light it on fire, it can spread and harm people, so I think our rule accounts for that being arson too. This is why I say we're asking for a narrow rule. We're asking only for when an item, piece of property, is attached to a structure, and you set a fire inside of it that can't spread.
So if hypothetically, prison doors were wooden doors capable of spreading beyond the door itself, then it would be a part of the building?
No, I think my point was that a door that's attached to the building, right, at that point, I think it's pretty clear to anyone that if you set that door on fire, there's a risk of it spreading to the rest of the building and hurting people. I think our rule would say, yes, that is arson too.
But it doesn't apply here because it's metal and metal doesn't.
Well, it doesn't
spread.
apply for two reasons. One, it doesn't apply because it's not the door. It's a piece of jail property attached to the door designed to contain fires. That's the whole idea, is that it's been designed for that purpose. It's a piece of metal that fire can't escape from it. An example we want to give is something like a wall safe. You install a metal wall safe into your wall, you put some papers inside of it, you
So
set
when they
that.
start the fire here,
What's that?
when they start, a fire started in that cuffing port, it's not arson. What is it
It's
just
actually-
criminal mischief?
No, it's arson in the 5th degree. The arson statute already has a mechanism for dealing with this.
It's just a degree.
That's correct. Arson in the fifth degree deals with intentional fire set to property of another.
So this is just burning property?
Yes, this is burning jail property.
So you're not arguing that Mr. Sidbury lacked the intent to set a building on fire? To cause damage to a building by fire?
I actually think I'm arguing that our question really isn't about his intent. It's
Okay,
about whether he in fact damaged the
I'm sorry.
building.
That's what I want to clear up. You're
Yeah.
not arguing anything about his intent.
That's correct. We're only arguing whether he did in fact
Well-
damage the building. Because
well-
this isn't a building, is what we're arguing.
Well, you're really arguing, not even that, you're really arguing what is a building.
Correct.
That's the limit of your argument.
That's correct. It's about what is a building. And in this instance, it's not, because fire cannot spread outside of it to the larger structure or the people inside. And I think this is why we brought up the wall safe example.
Can it spread if they're trying to put it out?
I mean, I don't, I guess.
I mean, if it's sealed, don't they have to open it and risk the flames flying
Well,
out?
interestingly enough, in this case, no, because there were no flames. If you look at records, Appendix 2, 725, 726, there were no flames in this case. It was just a small bit of smoke on a piece
Well,
of
let's
paper.
take this hypothetical. You
If
got-
there were flames inside of it. and
Get
a-
to it in time to open it and there are flames. I understand it's supposed to contain, right?
I think that might be a question for a fact finder at a trial, right? They could say, the prosecution could certainly call a witness to say that when this opens, the flames could escape, and the judge could then give an instruction that under those circumstances, this is a building. If the court issues a rule that says that closed containers attached to structures are not a part of the building, then obviously there could be exceptions to that worked out in future cases.
But if it just damages the cuffing port, you say that's arson 5.
Yes, that's correct. And this is just a cuffing port. I think I want to get back to, I want to make sure I get that wall-safe example.
But somebody asked about a doorknob before. Suppose he instead had held some fire under the doorknob. Same answer?
I think that because if it's possible that setting a door, putting a piece of, lighting a doorknob on fire could spread to the rest of the building, then I think our rule accounts for that. Because our rule only includes, it's very narrow, it only includes closed containers attached.
No, but my question is the doorknob part of the door? That is, here you've conceded the door is the building.
So, I think actually the answer to your question is in the rule we've proposed. So in our rule, we say anything that the word building should be limited to those things that are if they are attached to a structure.
That's your general rule, but in this case, I think you said you're stuck with the proposition that this door is the building.
That's correct.
So is the doorknob the door, or is it a fixture like the cuffing port?
I think that the doorknob would be, because if you set the doorknob on fire, it could easily spread to the door, the walls, the floor, the ceiling, and it could harm the people inside. The difference between the doorknob and the cuffing port is designed to contain the fire inside of it. A doorknob's not. A doorknob's not like that. You set the doorknob on fire, it could spread all over the place. That's the big difference.
Excuse me, what do you mean when you say the cuffing port is designed to contain the fire inside of it? Is the primary purpose of a cuffing port to contain fires? I thought it was
No.
to cuff people.
No, sorry, I think maybe to be a little more precise, the design of the cuffing port is such that fires are contained within it when it's closed. That's the testimony from Officer Arias on pages 608 and 609 of the appendix.
So it's designed with some sort of fire preventative mechanism. It's got like a little metal wall that comes down or something like that?
It's all metal, and then there's a thick plexiglass lid, and the officer says if it's closed, a fire can't get outside of
I
it.
just want to try one more time, and then I'll give up. I think it seemed to me, from what you said so far, that it matters greatly to you that the cuffing port is a fixture and is not part of the door, right? Or not?
So I think it's, sorry, I thought I'd answer, but let me make it clear. I think that the question of whether it's part of the door is somewhat semantic when you look at the rule we've proposed. That's why I'm trying to give the answer I'm giving.
Can you explain then what you meant by it's a fixture?
No, I'm saying that they are arguing that it's a fixture, and therefore it should
And
be
you
considered
say
part
it's
of the building.
not a fixture?
I'm saying that using fixture as a concept has significant issues.
So what is it then?
What is it? It's a piece of jail property attached to a larger structure.
But not a fixture?
I mean, maybe it is. The problem is that the test for fixture is this multi-pronged test for matter of metro media. And if this court was to decide today, in line with what the prosecution argues, that fixtures are now incorporated, that law, matter of metro media, is incorporated into the arson statutes, and anything that meets it as a part of the building, even then we would have to
If
remand.
I've got a door with a window, is the window part of the door? Is it the door also?
I believe the window would be, in most circumstances, yes. And I think the difference between a window or a doorknob or anything else is that none of those are detachable pieces of property that, when closed, contain fires. That's why I keep bringing up a wall safe. You could install a wall safe into a wall, correct?
Wait, can I ask you, though, if you remove that cuffing port, are you saying there's something else there that keeps the door closed in prison?
I mean, yes, there's a lock on the door. There's no way for anyone.
That hole? Would that
Yes, no,
still
no.
exist if the cuffing
The
port
hole would be
wasn't
there
there?
if you remove the cuffing port. Yes, there would be a hole in
Okay,
the
so
door.
like the same example, if it's a door and a window, like a window in a door, if you suddenly took out that window, you'd have a hole in the door, and I think we'd argue that the door has now, its integrity has been damaged because rain would get in or whatever. That wouldn't be your door anymore.
And this is why I think it's very important that you also pay attention to the facts in this case, which is that in this case, they didn't remove the cuffing port. They didn't remove it. They just left it there.
But I'm just, we're trying to figure out how intrinsic it is to this door, and if it's actually the door, or if it's, like you say, something that's just attached that could be easily removed, and you walk away with it,
So-
and it doesn't impact the functioning of that door.
I understand the question, but I think that it gets away from the purpose of statutory interpretation. Statutory interpretation, text, purpose. Text doesn't answer this. Text just says a structure with roof and walls. We look to purpose, to protect buildings and the people inside of them from danger. That's arson in the second degree.
Can we look to analogy? You talked about a Nintendo before. You said the Nintendo on the living room floor is just property in the building. It's not part of the building. How is a cuffing port like a Nintendo machine?
I mean, they're not necessarily that similar. I think the biggest distinction would be that the cuffing port, actually the most interesting thing is that you set
Relative
fire.
to Judge Singus's line of questioning, if you pick the Nintendo up from the living room floor, it leaves behind no trace that it was ever there. The integrity of the building is completely intact, and unless you had a videotape, you wouldn't know. If you take the cuffing port out of the door, I hate to repeat what she said, but then you have a big hole in the door. That makes it seem like a very different thing, even if you could call them both property.
Because its functionality is impaired in the circumstance where you take it out of the door, no? Which is completely different than the PlayStation, Nintendo, whatever you have on
was
the
it
floor.
PlayStation?
I
I'm
don't know,
sorry.
but anyway.
So I don't think that's necessarily the right way to go in terms of functionality. For one thing, because there's certainly no language in the statute that says functionality is the test for how we determine a building. One example of this, and we cite in our briefs, is that there's a case in which someone tried to set an oven on fire. It was put out before it spread to the rest of the kitchen, but in that
Yeah,
circumstance.
but the oven, like the bathtub or the PlayStation, can certainly be removed in a way that's different from taking a cuffing port out or taking a window out of the window frame.
That's true that you wouldn't have a hole in the kitchen if you removed the oven. I understand where Your Honor's coming from. I still think the court has to be focused on the purpose of the statute, which is to prevent danger to people and.
So am I understanding your argument turns on the fact that because the cuffing port is intended to be at least relatively fireproof, that it poses less danger?
Absolutely. I mean, I believe that is the exact testimony from the case, is that the cuffing port, it's unusual, and the rule we're proposing is quite narrow for that reason. We're asking that a person not be convicted of violent felony content and get 25 years in prison for lighting a small bundle of papers on fire in a box designed to that is designed in such a way that the fire can't spread outside of it. That stretches so far
Okay,
past.
but that's not what, it was stated earlier. It's a cuffing port. It wasn't designed to thwart fires.
No, I think I'm sorry. I feel like I'm being misunderstood. I'm not saying that when they designed it, they thought, let's design a fireproof cuffing port, although I do think that's part of it.
I'm interested in the preclusion of the psychiatric evidence.
Oh, I was
or
going to
are
ask if
you
I could
not
reserve some time to address
interested?
that in rebuttal.
Because your
3
light,
minutes. Yeah.
your light is on. So I was wondering if you were interested in that argument.
Sure, I would love to address it for a couple minutes if your
Why
honors
don't
would
you
be
take a
fine.
couple minutes?
Yes, so and that claim, we believe, comes down to this court's decision in People versus Burke, which incorporates the Supreme Court's decision in Illinois versus Gates, I believe, I'm sorry. 25010 erects a sort of structure for dealing with late notice. But the Supreme Court has held that you cannot preclude the entirety of someone's defense under a state notice statute without first making a determination of whether there's prejudice to the other side from that late notice. Burke holds that explicitly. Burke says,
Was there any analysis done by the court as to prejudice?
no.
Or
there was-
anything?
No, there was no claim of prejudice made by the prosecution below. The court never mentioned the word prejudice in its ruling. It never comes up. There is
Did the
no.
court seek an inquiry from the people or just summarily denied?
No, the court asked the prosecution for its response, and the prosecution did not give a response. They just said it's late, and it shouldn't
This
be
seems
allowed.
basically to me like a protective or prophylactic notice because there's no specification yet because the doctor hasn't done the exam. Is that a fair characterization?
So I think that the actual piece of paper is, doesn't specify.
No, but I mean, when asked, I didn't think I saw anything that elaborated, and that was because I took the record to suggest that that was because the doctor had not had an opportunity to examine the defendant yet. Is that right?
Slightly. That's true basically, but I want to make a couple clarifications. I think it's more than that. So the doctor they hired, Dr. Goldsmith, had examined Mr. Sidbury for the
Yes,
purposes of
previously.
competency.
I mean, in regard to the.
That's correct. He had reviewed all of his records going back to his daycare when he had his first psychiatric
Yeah.
appointments. And he had said to the attorney, based on the review and these other exams,
Didn't the attorney basically say, I can't provide any more detail now because I need the other lawyer to come back and I need the doctor to do another examination?
Yes, so Dr. Goldsmith
So-
said, despite these conclusions, I do need to examine
That's what I
him
mean
one more
by
time.
saying
So
it
yes.
is protective in that it doesn't provide perhaps complete specificity. Is that fair?
I think it's fair to say that there was going to have to be more done before he could iron out the defense, although I do want to make the point that, once again, the statute and even the court in Almanor has said that, adjournments are appropriate to allow this development to happen when there's no prejudice to the other side. And again, the Constitution places a limit on the court's power to preclude the entirety of a defense when there is no prejudice, and that's because the point of the notice statute is to prevent prejudice. That's the sole purpose of it, is to prevent prejudice to the other side.
I thought that counsel had, correct me if I've misremembered the record, had made a representation that the doctor was going to make a particular diagnosis, but would not finalize that until he again interviewed the defendant. So there's more than just, I may want to put this kind of defense before the court, but rather a representation that the doctor, more likely than not, is going to back up this particular position that we're going to argue, but he needs to have this interview to finalize it and prepare a report.
That's why I was somewhat reluctant to say it was just a protective application, because he has examined Mr. Sidbury, he's looked at his records, he says,
Yes.
I prepared to testify to this, but it's almost like a matter of professional thoroughness. I want to do an exam specifically for that purpose, prepare a report, and then I will be done. And I want to make clear also that counsel stands up in front of the judge and lists, here are Mr. Sidbury's diagnoses, here are the fact that his medical record, his psychiatric conditions go back to preschool. He has bipolar disorder, personality disorders, post-traumatic stress disorder. It's not like the bare bones representations that have been precluded in the past, where counsel refuses to give any detail late in the game.
And in this case, trial was still some 6 weeks or so away.
That's correct. Yes, it was prior to trial. There would have been no prejudice to the prosecution here because Mr. Sidbury had not yet, actually Burke speaks exactly to this scenario. This court has said when the notice is late, but the defense has not yet actually had their client examined for the purposes of the defense, both sides are on equal footing. They're both going to be
But
examining.
isn't this a little different? Because we're not talking about a late notice. I mean, the statute says 30 days. This was 4 years later. It was the same institutional provider. 2 730 exams had been done alerting everyone about issues. So I feel like these particular facts are a little different than how you're presenting them.
We don't deny that the delay was extensive. We don't. The difference, though, is that just the number itself does not establish anything, right? They still have to make a claim that it prejudices their case. They never did. And the reason why is they would both still be examining Mr. Sidbury at the exact same time. There's no advantage to the defense in this circumstance. If they had had Mr. Sidbury examined a week after the incident and then waited 4 years to give the prosecution the results of that examination, now that would be prejudice. There are cases where preclusion happens in those cases. But Burke explicitly holds, and it mentions as an example of no prejudice, when the exams are happening at the same time.
Let's hear from the ADA, and I'll give you like a minute of rebuttal at the end.
Sure, thank you.
Good afternoon, Your Honors. Lori Farrington for the people. Your Honors, to start with the first point regarding the jail cell door. Viewing the evidence here in the light most favorable to the people, the appellate division's decision that there was legally sufficient evidence of damage to the building should be affirmed. Defendant set fire to the cuffing port of his jail cell door, which was a built-in integral part of the door, as the defense concedes.
What do you say to the claim of the defense about its being readily capable of spreading?
There was no evidence that a fire could not spread beyond the cuffing port. In fact, when Officer Arias was asked about that, his answer was, well, it depends if the plexiglass lid breaks. And then he was asked, well, in this specific situation where it did not break, would the fire spread? And that is when he said he did not believe so. However, Officer El Serafi, as a result of this fire, was treated for smoke inhalation. The plexiglass lid was burned to the point that there were 2 holes in it through which smoke could escape. So to say that this fire could not endanger the inhabitants of the building is simply untrue, especially when you are dealing with a jail building where there are hundreds of vulnerable people locked inside
Can the
that cannot
endangerment include the smoke or fumes and not just the risk of this fire itself spreading to other parts of the building?
Well, the legislature, as my adversary states, was concerned with the danger posed to the inhabitants of the building.
Yeah, so if the cuffing port is such that the fire itself can't spread, but there's smoke or fumes that can dissipate through the building and affect the folks that are inside, is that sufficient?
Yes, in terms of
And why is that?
intent of the statute.
Yeah, that's what I
yes.
mean. And
Well,
tell
there
me-
has, in terms of the statute, there has to be damage, and there was damage here. But defense's argument is predicated on a factual notion that is incorrect, that this fire could pose no danger to those inside because it could not spread. That is not true. And in fact, the trial court asked trial counsel, how can you claim that this fire could not spread beyond the cuffing port to the door? And trial counsel said, I could not do that, Your Honor. So yes, these cuffing ports are made of metal, and in fact,
There can be fires that are set inside an inhabited building that could injure people, even though there's no damage to the building, right?
that is correct, Your Honor.
So that
Yes.
wouldn't, in that circumstance, that wouldn't be arson in the second.
It depends on.
No damage to the building.
It depends on the items that were set on fire. And for example, I'll use the same case that my adversary cited where there was a fire set in an oven. That was found sufficient for attempted second-degree arson, despite the fact that there was no damage to anything.
Well, attempt doesn't require actual damage.
Right,
So,
but setting the fire in the oven that resulted in no damage anywhere
Right.
was attempted second-degree arson. Here we have
leave
damage.
Leave attempt out for a minute. The second-degree arson statute requires damage to a building. yes?
Yes,
You can set a fire inside a building that is inhabited, let's say in a huge garbage can,
correct,
that does not damage the building at all,
correct.
and that injures a lot of people through smoke inhalation.
Through smoke and leak? Yes,
That would
however,
not be arson in the second.
that is correct,
Okay.
because there is a qualitative difference between an item such as a garbage pail that can readily be brought outside to minimize the damage to the building and to minimize the risk to those inside of the building. Here, that situation is not present, and that is why we felt that the law regarding fixtures was instructive. And to be clear, we're not asking that the real property law be wholesale incorporated into this, but it's instructive in discerning the legislative intent, given the legislature's focus on the damage, the risk of injury to those inside the building. So a garbage can fire inside a building can much more readily be extinguished, brought outside, stopped from spreading, to minimize the danger of smoke inhalation, in addition to minimizing the danger that the flames themselves will spread. So yes, that presents a very different scenario, and that is the type of situation the legislature attempted to address when it included in 2001 the misdemeanor charge of fifth-degree arson, which is setting fire to the property of another, or damaging the property of another. And those are two very different circumstances. And to use the example that was brought up before of a bathtub, obviously a fire in a bathtub presents a far greater danger to the structure itself, as well as to those inside, than would a fire in a garbage can that happened to be inside of a building.
Can you get to the psychiatric defense? What was the people's prejudice?
Yes. Here, the trial court absolutely did not abuse its discretion in declining to accept the egregiously late notice. In fact, it was defense counsel who brought the issue of prejudice to the people up before the trial court, before the people even had an opportunity to
So what
speak.
was that prejudice specifically to the people?
Here, the prejudice here would be that any exam that the people could conduct 4 years after the crime would be neither in close temporal proximity to the crime, nor meaningful, nor reliable.
And where's that set forth in the record, that point was made by people in the moment?
Your Honor, it wasn't, that point was not specifically addressed, but the issue of prejudice was raised and therefore considered by the
But don't you
trial
have
court.
to specify what the prejudice is for the court to determine whether perhaps he should be granted the opportunity to have that exam done?
Well, Your Honor, the prejudice is, first of all, is inherent in the delay itself. Second of all, the trial
So
court
are you saying the court did assess prejudice and identify a prejudice to the people?
The court did assess prejudice, yes. It did assess.
What did it say about prejudice?
The court assessed well, first of all, it assessed under the statute the good cause and the interest of justice. Interest of justice incorporates prejudice.
So I take
any
it you're saying there's
analysis-
an implicit, there's nothing explicit, is that correct? But you're arguing there's an implicit assessment of prejudice?
Absolutely, yes.
Okay, but nothing explicit.
Explicitly, the trial court did not say, I find no prejudice in those explicit words.
Or
no.
ask the people to identify prejudice, correct?
No,
And
but
did-
again,
and
the
did the-
issue was raised.
Did the people say we are prejudiced, even if they didn't explain how?
The people did not raise the issue of prejudice. First, the issue was raised by counsel, who said, the people are going to claim there is prejudice. Where is the prejudice? So the issue was before the trial
And then
court,
did
the people did not
they
reiterate
said
it. No.
nothing? They said nothing in response to that?
The people did not reiterate that. No, that is correct. That is
Not just
correct.
reiterate,
But-
but did they make out a case for prejudice? I mean, it's one thing for counsel to give the court a warning that the people are going to argue prejudice, but I'm sure defense counsel nowhere in the record makes out the people's case on prejudice for them. So my question is there anywhere where the people get up and say, yes, here's the promised prejudice argument, and this is what it is?
Based on the trial court's, the colloquy between trial court and counsel, that record was not necessary in that
You mean
moment.
between defense counsel?
I'm sorry, between counsel, defense counsel.
Okay, but not the people.
No.
Okay.
There was a very lengthy colloquy back and forth between defense
So
counsel
the
and
people
the trial
never
court.
identified or articulated specific prejudice as to this delay?
No. And as this court has found and has addressed, that the statute, the notice statute itself incorporates that notion of prejudice, that the reason for the 30-day time limit is so that the people have the opportunity to conduct a
But even
meaningful...
if there is a delay, and you're outside that 30 days, the reason there's a discussion about prejudice is whether one should exercise discretion and still allow the exam to take place, correct?
Correct. And here...
So if you don't identify what your actual prejudice is, how can you say it's not an abuse?
The trial court had the opportunity, the issue was raised. Granted, it was raised first by defense counsel, who stated they are going to say there was prejudice. The trial court had the opportunity to consider that. The trial court considered all of the factors.
But not knowing the parameters of the claim. I think that's what the Chief Judge and Judge Canataro in part are getting to when they say, just saying they're going to raise prejudice is not telling the court what is the argument from the people's side as to the nature of that prejudice.
That is correct. And here...
Suppose the people had then said at trial, the prejudice is we're 52 days away from trial, and we can't hire and retain an expert and have that person review the other side's expert in that time. And the prejudice to us is we can't do this. And the court then might say, well, then we'll put the trial off for another 2 months. That would address that prejudice if that's what the people's prejudice was.
Right, but pursuant to this court's precedent in Burke and Almanor, the statute provides for a timely and meaningful exam. This exam could not be timely, it could not be meaningful,
And if the
there's-
people had said that, that would be different from the hypothetical I gave you, but the court at least would then know what argument it was addressing. Right? We normally ask people to preserve arguments so that in a situation where the court is called on to rule on arguments and make a decision and see how something can be mitigated or not, if you don't know what you're trying to mitigate, how can you do it?
Well, as your honors are aware, preserving the argument requires that the trial court be informed of the general nature of the argument, prejudice. Here, the trial court was well aware of that. It addressed...
No, but if you agree with Judge Troutman that the purpose of the showing of prejudice is to give the court an opportunity to exercise its discretion, to make an effort to ameliorate the prejudice and allow a defense that, defendant might be entitled to bring or not, then you have to really articulate what the prejudice is. If the argument is, look, it's 4 years after the fact now, there's no way that even if you let us hire our own psychiatrist, there's no way they're going to gain meaningful insight into what this defendant's state of mind was 4 years ago. That would at least tell the court something about whether it could exercise its discretion or not. Don't you think by not saying anything, you deprive the court of that opportunity?
No, because the court did address, not in those exact words, but the court did address the delay repeatedly.
Do you
and did
agree
address-
that the court has to balance that against the defendant's constitutional right to present a defense?
Yes, in terms of the defendant's due process rights, of course. And that's one reason that the court found a lack of prejudice
But even
here.
without...
But yes, of course, that's a consideration.
Even without the people specifying what their prejudice is, what was done here was fine. That's what you're saying.
Absolutely, yes, because the court considered it. The court considered the delay. The court considered the effects of the delay on both parties. The court considered whether counsel had shown good cause or that the interest of justice
Can I ask you about
required the late
the
notice.
good cause and a different point?
Sure.
I was struck by the fact that defense counsel's supervisor came in and said, on the record, it looked to me that there had been malfeasance, apparently in putting this defense, providing notice of this defense, or perhaps examining it. I couldn't quite tell previously. And the judge seemed to me to brush that aside relatively
Well,
quickly.
The trial, oh, I'm sorry.
I was just going to ask, what's your response to that? Should we be concerned about that?
The trial court repeatedly asked, where is the malfeasance? This was a reasoned and rational decision by the prior attorney from the same organization. That question could not and was not answered. The mere utterance of malfeasance cannot by itself suffice to establish good cause without gutting that requirement.
That's a pretty unusual word, I would think, to be used particularly by a supervisor who is with an organization that appears with some frequency in a court.
I would agree, Your Honor. But under the statute, to show good cause, there needs to be some indication that the malfeasance was not merely a disagreement in strategy. Perhaps Ms. Felber, who was the supervisor, disagreed with Ms. Moridoff's conclusion.
Does the
that there
record
was no-
say that?
No, because when the trial court asked, where was the malfeasance? What was the malfeasance? That question could not be answered.
Our office failed the client here. We're taking responsibility for it. Give him his chance. You're saying that's not what the supervisor was acknowledging, that it was their fault. And
No, Your Honor.
don't allow the client's constitutional rights to suffer as a result thereof.
Again, Your Honor, the mere utterance of the word does not establish good cause. Had there been, for example, had the
Does
initial
the mere
attorney...
utterance of the words, "Where is the malfeasance," establish that it wasn't, in fact, that
the
you know what,
inability to-
it also seems that they're saying to the lawyer, you're lying.
No, no, it does not hinge on counsel having been untruthful or lying, nor does it in any way
But they're not,
impugn the integrity.
so you're saying that the court didn't take the attorney at her word, this is, that there was malfeasance, but you're saying because there wasn't a sufficient articulation of the specifics of it?
No. The court, by asking the question, where was the malfeasance, what was the malfeasance, was saying, I need some information to determine good cause. I need you to tell me why this is not merely a change in strategy, which does not suffice to be good cause. I need you to explain to me how this was malfeasance versus change in strategy. That question could not be answered and was not answered, and I'm not saying that they had to provide extensive detail, but some indication that Ms. Moridoff was going to serve notice and forgot. Some type of malfeasance beyond a change in strategy. And there was no evidence of that. And it appears from the record that the supervisor had not spoken to the initial attorney and did not know whether it was merely a change in strategy because she asked the court, has previous counsel stated that the defendant is malingering? So yes, for good cause under the statute, the trial court was well within its discretion to say, tell me why this was not a change in strategy. For 4 years, he had active and engaged counsel who requested 2 730 exams. Tell me how this is not just a change in strategy. in a case that I have been presiding over for 4 years, that I have been the judge throughout both 730 exams, where this doctor that they now retained after 4 years had been examining the defendant for 2 years already. Yes, the trial court was well within its discretion to say, I need a little more information than that. And that information could not be provided.
Thank you, counsel.
Thank you very much, Your Honors.
Counsel, you're way over your time, but you can have 1 minute.
I'm going to correct a couple of factual inaccuracies. The first, the court never once asked counsel to say what was the malfeasance. That sentence doesn't exist in the record. Instead, what the court said is, everything I've said about your client over the last few years, there is no psychiatric issue. There is a malingering issue. Your client can call a psychiatrist all he wants. He has been established repeatedly to be fit.
Counsel, didn't the court also say, though, this could have been a rational and reasonable decision made by the attorneys in this case that there was no psychiatric defense?
Yeah, but the reason he's...
What if legal aid supervisor comes in and says, you know, we should have made this motion, it was ineffective assistance of counsel? Does the court have to accept that? Or should that attorney have to come in and say, yeah, I just, you know, I had no strategy here for this?
I do think the court needs to accept the statement of...
So in effect, can
I mean,
come in any time and say, you know, the lawyer we had on this case before was ineffective, constitutionally ineffective. We should have done this, and you've got to let us do it now.
I think
And you have to say yes.
In the absence of any prejudice to the other side, yes, because the constitutional right to present a defense and call witnesses
See how that
requires
could
prejudice.
be abused, though, right?
I think the way that it's not abused is to assess prejudice and to make sure that if there is no prejudice to the other side, then you aren't abusing.
So there's no prejudice. We can come in and we can say the guy had this before, it was ineffective, so you got to let us do it.
No. Actually, the law also has a mechanism that if a court believes that someone is willfully subverting the purpose of the statute, they can preclude. Multiple Supreme Court cases, Second Circuit cases that we cited.
Question, if we agree with you on this notice issue but disagree on the arson issue, what comes next?
It's a remand for a new trial.
And can the people then argue prejudice on the prior late notice that now it's 4 years and we didn't have a chance to examine this person closer to the event?
I mean, I think I would need to do some research on law of the case before I could definitively answer that question for you. I think that if counsel at that point makes a motion to bring in a psychiatric expert, they would still have to articulate how it hurts their case to not, and I want to make clear that the prejudice that's claimed here, for what it's worth, is unpreserved. It's raised only in the brief here. I also want to make clear that counsel saying that the court did consider prejudice is false. The court did not ever consider prejudice at any point in this case. And saying implicitly considered just means it wasn't considered.
Thank you, counsel.
So, thank you.